from a air possibility, so we air news updates. Me person say what that. You more fast. You see my all the way.
To fix that, but Sammy, let me come to you. You obviously are not happy with the decision of the Supreme Court.
Yes, Doc. Yesterday was a very sad day for me, and I believe all lovers of fairness, justice, and the rule of law. And it was a sad day for us because the judiciary, which is the foundation of our democracy and is supposed to be the bastion of the rule of law and the dispenser of justice, has unfortunately become the dispenser of unjust, unfair, and unjustified decisions in our country in recent time. And that, for me as a lawyer, is very sad, because if the judiciary does not, in deciding cases, does not uphold the laws of this country and do justice to people who run to them, then we have no hope as a people. And I believe that is what happened in the ruling that the Supreme Court delivered yesterday. Clearly, they did not do justice to the people of Assin North, and by extension, the people of Ghana. They did not do justice to Honorable jãił the MP for Assin North constituency. But look, even before we go into the ruling of yesterday, the issue of the
so these are the reasons of the majority view. They say that the High Court had declared the election of Mr. Kwesi null and void, and therefore allow him to continue as an MP while the constitutional issue was yet to be determined would be an indictment of the administration of justice. They say there can be no justification for ignoring the submissions on the continual disregard of the orders of the High Court, which have not been suspended or overturned. And they said the whole country will suffer a greater hardship if Mr. Kwesi was allowed to continue to serve as MP. And the court determined that his election violated the 92 Constitution. Says this court will be failing in its exclusive mandate and duty to the Ghanaian people to uphold and defend the Constitution if it does not suspend, mitigate, or abate an alleged constitutional illegality if the applicant were to succeed at the end of the suit.
You see, I was going to deal with these issues later, but since you've raised the issues, let me deal with them once and for all. First of all, if you read the 40-page ruling of the Supreme Court on this matter, which includes the dissenting opinions of the two justices who dissented on the matter, one of the main reasons they gave for granting this injunction against Honorable Kwesi, the MP for Assin North, is that they say that according to the applicant, Honorable Kwesi is in contemptuous breach of the Constitution of Ghana and the orders of the Cape Coast High Court. Because according to the applicant, Honorable Kwesi was injuncted on the 7th of January from holding himself out as a member of Parliament. And yet he went to Parliament, was sworn in, and participated in parliamentary proceedings for that day. They also make the point that at the end of the hearing of the Assin North election petition matter, the Cape Coast High Court nullified the 2020 Assin North parliamentary election and granted a perpetual injunction against Honorable Kwesi, restraining him from holding himself out as MP. And according to them, even after the High Court made this order, Honorable Kwesi has been holding himself out as the MP for Assin North. And so, in their opinion, Honorable Kwesi is in contemptuous breach of the Constitution and the orders of the Cape Coast High Court, and the Supreme Court should not allow him to persist, in that conduct during the pendency of the writs that they have brought before the Supreme Court. And the Supreme Court, on the basis of this, as has been reported by Graphic, says that, since the allegation is that Honorable Kwesi is in breach of the Constitution, in breach of the Cape Coast High Court's order of injunction and all that, then we have to injunct him. No, I cannot for the life of me understand why our apex court will grant an injunction on the basis of unproven allegations. What is the proof? Where is the evidence?
Are they not granting an injunction on the basis of a decision by High Court?
No, but it has never happened in the history of this country that the Supreme Court will grant an injunction upon an injunction. The Supreme Court cannot. I have never read any such case in all my training as a lawyer. No. Hold on. The Supreme Court cannot grant an injunction to enforce an injunction. Number two, the Supreme Court is not the forum for the enforcement of orders of the High Court. So if the High Court has granted an injunction against Honorable Kwesi,
is that what the High Court did?
That is what the High Court did.
I thought that what the High Court did was to nullify that election
and grant a perpetual injunction. That was one of the reliefs. So they have nullified the injunction,
the election,
yes, and they have granted a perpetual injunction restraining Kwesi from holding himself out as MP.
Yes.
That's the High Court.
Yes.
And I'm saying that if you want to enforce that, there is a way to enforce it. Every lawyer knows how to enforce a judgment. You must first of all go and do your entry of judgment and enforce it against the person who is to do an act or who is to refrain from doing an act. There is a way to enforce, and you enforce that judgment in the High Courts.
So this is the position of the minority.
No. I'm going to. This is the position of the minority.
The minority view on the bench.
But I've not even gotten there.
Yes.
My first point is that the reason for granting this injunction by the Supreme Court is that the applicants, the one who applied for this injunction in the Supreme Court, let me simplify the issue, says that, look, injunct Kwesi because number one, he was injuncted on 7th January not to go to Parliament and be sworn. He went. Number two, he's been injuncted by the Cape Coast High Court from holding himself out as an MP, and his elections have been nullified, yet he's holding himself out as an MP. So he's in contemptuous breach of the Constitution. And so even before you interpret Article 94(2)(a) on whether or not he owed allegiance to a country other than Ghana at the time of his nominations, we want you to injunct him. And the Supreme Court says yes. Since the applicant is complaining about breaches of the Constitution, which is the supreme law of the land and which the Supreme Court must at all times protect and enforce, and since all Ghanaians have a community of interest in matters of constitutional enforcement, we will injunct Kwesi. And I'm saying that, first of all, that is problematic because the allegations that the applicant has made have not been proven. It is not true that Kwesi is in contemptuous breach of the Constitution or the orders of any courts. And I say so because, yes, the Cape Coast High Court gave an injunction, an order of injunction, made an order of injunction on 7th January. That is not in doubt. But was that order of injunction served on Honorable Kwesi? Was it served on him and he decided to violate that order? It wasn't served on him. They, in their own words, claim to have served the clerk. And is that the way to serve a member of Parliament an order of injunction? So the Supreme Court, without taking cognizance of the mode of service of that injunction and whether that was proper or not, cannot accept hook, line, and sinker an allegation that Kwesi defied that injunction. That's number one. Number two, they say that the Cape Coast High Court has nullified Kwesi's election and has injuncted him. Again, has that judgment of the Cape Coast High Court and injunction been enforced by the applicants? Randy, I hope you understand what I'm saying. Yeah. Has it been enforced? It hasn't been enforced. And it cannot be enforced because immediately after that judgment was given on 28th July 2021, on that same day, Honorable Kwesi's lawyers filed a notice of appeal in the Court of Appeal and an application for stay of execution. And what that meant was that that judgment of the Cape Coast High Court and the accompanying order of injunction could not be enforced. And so how then can you say that even though Kwesi had a notice of appeal and an application for stay of execution pending in the Court of Appeal, he was in contemptuous breach of the Cape Coast